All right, we have everybody here. Okay, and I don't recall them. All right, who's up first? I'm sorry.
I'm Dorothy D. Fiore. I represent
Fiore.
Family Services.
You're up.
Thank you. This is an appeal in a case in which a writ of mandamus was issued to compel production of emails and text messages out of a dependency case. DT was sheltered and determined to be dependent. He was placed in a foster care placement. At that point, Youth and Family Alternatives, which is the subcontractor for the lead agency in the area, was assigned to the case. There became problems with that foster placement, and Youth and Family Alternatives was then involved in transferring DT to placement with his grandmother in, I believe, Brevard County.
Mr. Fiore, can I skip to a couple of things here?
Sure.
And be sure I have this correct. As I was looking in the record, it seems to me that there's the lower court issued two orders. One was the early alternative writ, styled alternative writ of mandamus, and then the other there was just, it was called an order, and it was like that wrapped up the other items that were not mentioned in the first one. Those are the orders we're talking about.
So we were really only talking about the last order. There was
right, but to the extent that either one of those orders dealt with items that were public records under Chapter 119, they are not part of your appeal. You're not complaining about those. So
I believe the issue is, what is the case record to become part of 119?
Well, no, I don't actually, I question that. It seems to me that the case record is part of Chapter 39. Okay. And this is part of this. One of the things that's confused me about this case is because the writ of mandamus was asserting an obligation to act under both Chapter 39 and Chapter 119. But it seems to me that Chapter 30, these records are confidential and excluded from 119, correct?
Yes.
And then the exception to that is in Chapter 39, not 119.
Exactly.
Do you, and you are agreeable, for instance, to furnishing like the texts and emails, but charging for them under Chapter 119?
Correct, because we don't believe they're part of the case record that must be produced for free.
But do you believe they're confidential?
From everyone outside of the child and the people involved in the dependency case, yes.
Well, okay.
I mean, these are topics about minor children and dependency provisions. That's, generally speaking, that's confidential in any context. So, yes.
Okay.
Okay.
Go ahead, I'm sorry.
Right.
I was just trying to get all this straight in my mind.
So the request came in and it asked for a lot of documents, and ultimately the Youth and Family Alternatives did provide everything but the text and emails. The request was very specifically for all text and emails, and not just text and emails about this dependency case, but also about the minor child, which makes it incredibly broad in scope.
And the orders say that as well, correct?
Yes, they do. And so in the course of this proceeding, and again, I am not challenging that a writ of mandamus was appropriate for the insurance policies and the documents out of FISBIN and things like that, right? Because that's very clearly part of the case record and subject to production. And that was done, I think, by July 15th of 2022. So we're only talking about whether or not a subcontractor for the lead agency is required to produce every single text and every single email about even the minutest and trivial things, and whether or not documents that might be related to this child that have nothing to specifically do with the dependency case are also subject to production. And the Department of Children and Families came in to address a little bit about that overbreadth of asking for all documents about the child, because there are audits and quality assurance processes and things like that that happen that are not necessarily part of the dependency case, but they technically reference the child. So we have a scope issue as well as is this in the case record? So in order to look at what is the case record, we start with what did the legislature say, and the legislature laid that out very clearly in 39.00145. and stated, it described a lot of things. I put that in the brief. I'm not going to go through them all. Does not at all mention text and emails. It mentions the information that is in the case record and
well, you would agree though that the way the legislature wrote that section is that the record must contain at a minimum. So it's a non-exhaustive list.
Absolutely. And in fact,
however, the legislature didn't say it must contain everything, every record, every document related to the child.
Exactly.
It said a minimum,
right?
Which I suggest to me that there is discretion beyond the minimum.
And there is to a certain extent, except that DCF then took the legislative mandate of, the case record and what is a minimum. And in order to really
engaged in rulemaking.
Which is their, delegated legislative authority. Right. And they specifically went through. And the thing to understand is that the FISBIN system is a computer-based system in which people that are located around the area have access to the information, and it's about putting in information. Now, a lot of the information is in a module that can be printed out to look like what we would have typed up years before, but now it's on a screen. You type in this, fill out the screen, and if someone says, I need to see the case plan in a piece of paper, then you can print it and send it to them. But otherwise,
let me ask you this. And you are describing this system. Was that set forth in any evidence in the lower court?
So it's not in anything in the record because
was there any evidence taken in the lower court?
Not that I could see. It was a writ of mandamus. It was about a half-an-hour hearing, and it involved a lot of testimony and argument.
Okay, and that's from the attorney. Okay, and when did that happen with regard to the first order or the second?
Second order in October.
Okay.
So yeah, and that's part of our concern. Obviously, we've raised two issues. We think that substantively the ruling is incorrect, but we also think procedurally we got there in the wrong way because the legislature.
I would like to ask you a question about procedurally.
Okay.
I want to make sure I understand your argument on the impropriety of mandamus. And so the way that I simplified it is you're basically saying this isn't to make an analogy to certiorari. This is not what the trial judge did here involved sort of cobbling together her own definition of what is the record within the meaning of Chapter 39. And that regardless of the propriety of how she did that, it wasn't such a clear, bright line legal standard that would support, right, that this would support the issue, this extraordinary writ. So in my mind, just bear with me, in the back of the room, your argument is very similar to someone saying in a certiorari case that you haven't violated a clearly established principle of law. Do I have that correct? That's really
I wish I could have thought of that. But yes, and because mandamus is about a very specifically unquestioned, clear, no doubts about it, legal duty of the state agency to perform that task, once we came to the end of the statutes and the rules, we left mandamus. And it should have stopped, and we should have had some other type of proceeding. Either it's a deck action or it's a full-blown evidentiary process to determine this issue. And I'm not saying that Judge Barkley couldn't have done that in this proceeding, but that wasn't what was done. And as a result, and from my perspective, when I look at what the DCF has said, they looked at at a minimum, they went beyond what's specifically mentioned in that statute, and they said, we're going to keep this and we're going to put that. And again, the main focus is on information, because it is a system in which we are inputting information and not necessarily attaching documents. The documents are generated from the data that's within the system. Are there outside documents? Of course. There'll be medical reports, there'll be school records, there'll be things like that must be part of scanned into the system type of thing. But
and the rules provide for some documents to be uploaded into this system.
Exactly. And the DCF didn't set FISBIN up so that all communications like emails are within the system so that they're automatically saved. And so substantive information is important and is in the FISBIN system. So the contents of emails that are substantive and significant to the case, relate to the issues that are being followed, those are either typed in or copy pasted in. And if you've ever seen in the record, some of the dependency records, you've probably seen in the notes, the daily notes that are typed up, that are referenced in the rules, you've probably seen copies of emails, copy pasted right in. So the substantive information is in FSBN a lot of the time. I'm not going to tell you it makes it 100%. We're human. All these caseworkers are very busy. Sure, there could have been something overlooked. That might have happened. I will tell you that there is probably no text messages in the FSBN system because the process of getting a text message in the computer system is far more complex.
If any of these items, texts or emails, had been uploaded, the department would have no problem disclosing those under the statute that says the child has a right to see the case record or the case file.
Well, it's in FSBN at that point. So
but if they're not in there,
right?
And that's where we're at now. So
exactly.
The judge has, okay.
So yeah. So when you look at what DCF
Mr. Forey, may I interject with just one, hopefully a simple question? I know you mentioned the brief that if they pay for this amount, you'll be gladly turn this over to you. So this whole case comes down to cost.
Not really. I mean, it really doesn't. It comes down to what is the process that these caseworkers and all of the people in the system, what is it that we're asking them to do in their daily business of providing case
well, let's come back. The judge said you have to release all emails and texts essentially related to the child. And you made an argument that this oversteps because the department is the one that makes that rule, what goes in, what doesn't. But you're willing to turn those over under Chapter 119 if the child pays pursuant to Chapter 119, reasonable fee for the research and copying and so forth, correct?
Because it would not be part of the case record.
Right. So the issue here is whether you have to research and copy and produce those things free of charge under Chapter 39. Correct? I mean, that's the very narrow issue that's in front of us.
I still think that as broadly as the judge defined this, she has made all texts and emails.
Well, yes, I know. I see what she did, but she said that you have to produce them under Chapter 39 free of charge.
Well, that would make them part of the case record, and then it would need to be in FSBN. And the DT is arguing that, in fact, the case record is broader than FSBN. And if you look at those rules, DCF has said that FSBN is the accurate and complete record of the child's dependency process. So we think from what we see in the rules is a very careful decisions about what constitutes the case record. And the DCF and all of its contractors have to comply with those record keeping responsibilities to put that substantive information in. So there should be no need to ask for anything outside of FSBN unless you get in there and see someone's dropped the ball and not put it in. Sometimes a case plan doesn't get into the FSBN system, and then you would look and say, where's the case plan, right? Or where's the judicial order? And it's not in here. So sometimes things don't get in. And
well, let me ask you this, and now we're now into hypotheticals. But assume, for instance, a child requested a copy of his or her file, case record, and there was no case plan in it, and pointed that out to the department. Would the department then go find the case plan and upload it into the file so that it becomes?
Yes, because that's one of the mandatory things that's supposed to be in there.
Right. Yeah. But emails and texts don't fall into that category.
Not from
any other information outside of what's been listed under the rules.
Exactly. And again, the substantive information gets in there so that when the FSBN is produced, it does give them a lot of the information. So that brings us to the point that, in fact, in this appeal, they have backed off of their argument that they're entitled to all texts and emails. And now they're only saying it's about substantive. The court said the case managers can't make a decision and can't have the discretion about what's in the file and what gets put in there. They have to put it all in there, and we can't leave that to the discretion. But in fact, they've said in here, well, no, we're not asking for every little email that just has a thumbs up emoji or a text message, that type of thing. When they backed off of that, I see Ms. Schleier's shaking her head no, but in fact, in their brief, they said, that's not what we're doing, because we pointed out that it would be so overbroad that it would include just unnecessary information so then we get into, well, what is the important and necessary information? And that becomes discretionary, that becomes not a bright line rule, and then we're outside of mandamus. And in this case,
Ms. DiFiore, I didn't make a note contemporaneously, and I don't recall whether you said you wanted to reserve rebuttal time, but you're down to 5 minutes.
I'll take that as rebuttal time. Thank you.
Okay, that's fine. Okay, Ms. Appley.
Thank you, Your Honor. May it please the court. I'm Leah Schleier. I represent the appellee in this case. That's DT, who's a minor child by and through his permanent guardian, DT2, who's also the petitioner below on the writ of mandamus issues. I don't think that there's any dispute that Youth and Family Alternatives was required to comply with Chapter 119 and Chapter 39 as a private agency doing the work of government, doing the work that the Department of Children and Family Services, Children and Families has been tasked with doing.
Let me ask you this, because I'm trying to figure out how they fit together here.
Sure.
So if you've got a record as defined under the public records law that relates to the dependency, and chapter 39 makes all the records confidential, correct?
With respect to the public at large, the records.
It makes all the records confidential, and the exception is the case record for the child.
There are two sections of Chapter 39 that are important.
Okay.
One is 39202 that discusses all records that should be held confidential except with respect to designated individuals. That includes the child or the attorney, having to do with reports of child abuse and neglect, and all records generated as a result of such reports.
Okay.
That's 39202. 3900145, which I think is the one really at the core of this appeal, from what I've gathered. It provides that all records in a case record must be available for inspection upon request to a child or his attorney, and further that a complete and accurate copy of any record must be provided to the child and the attorney.
That's any record in the child's case record.
That is correct.
Okay, so the question I was trying to get to is what provision under Chapter 119, under what provision under Chapter 119 would you access anything else?
Well, there are other kinds of records, and to some extent, the amicus by DCF talks about that. And we're not talking about those other records in this case. They might include licensure records, for instance, in foster care.
Well, let me come back. Chapter 39.202, all records and reports of the CPT, of the Department of Health, are confidential. Okay. And then, and so forth. These records are custodians of records made confidential. And then you have, and this is, notwithstanding Chapter 119. I mean, it says notwithstanding, and basically are exempt from 119.
Correct. So
then you have 39.202 that talks about the case record that they have to show, but certainly the case record would be included in all records are confidential. How does 119 ever grant you access to anything having to do with the dependency?
Well, Chapter 119 comes into play in this specific context because it's Chapter 119 that provides sanctions and penalties under 3900145 when those records are not produced.
Does Chapter 119 reference 39.00145?
It doesn't, but 3900145 does reference 119.10.
I was looking for that. Oh, wait a minute.
subsection,
Subject to, I see, subject to sanctions and penalties under 119.10. Okay.
correct. So it dovetails.
Ms. Mayor, if I may, and I think the crux of this whole case boils down to, is this appropriate for mandamus? And when you start with that premise, then you go through what's appropriate for mandamus. If it's dealing with some discretionary aspect, that takes it off the table. So I think that's where try to streamline into the essence of this case.
I appreciate that, Judge. So there is a clear legal right, and we established that right.
Why is there a clear legal right to texts and emails that are not in the case record as maintained by the department?
Well, they are part of the case file, in fact, Your Honor, and both parties have relied here on the Administrative Code Rule 65C 30.001 and subsection 12 very specifically. And in there, and it's very interesting because I think what appellant is trying to do is read into 39.00145 that FISFIN somehow comprises the entire record. And then with respect to this Administrative Code Rule 65C 30.001, they're trying to delete or ignore part of what that rule says. And this is a rule promulgated by DCF itself, right? And so, as we know, administrative rules, to the extent that they're contrary to the statute, don't have to be deferred to. But in this case, I would submit to you that they're completely in line.
Well, I'm trying to read the part of the part of the rule that these emails and texts come under as part of the case file.
The rule talks about not only FISFIN constituting the case file, but also the supporting documentation gathered during the provision of services to that family.
Now, how are emails and texts supporting documentation gathered? Wouldn't supporting documentation mean like a medical report? There's a documentation that's gathered, but not anything created during the investigation.
Well, I would submit that it is something that's gathered in the course of providing case management services. These emails contain information on what was done in a case and what was not done. And so they are the supporting documentation with respect to the case management activities undertaken by the agency. And in fact, in that, supporting documentation is twice referred to in that administrative code rule. The other thing that appellant has said,
both of them talk about supporting documentation gathered, correct?
That's what the statute says, Your Honor.
No, that's what the rule says.
Well, pardon, yes, the rule.
And this, okay, and so so we're down to trying to decide whether the court properly determined that an email or text created by one of the caseworkers during the investigation is a supporting document that has been gathered for purposes of this rule.
Yes, Your Honor, but also if you go back to 39.202, it talks about, all reports not only concerning child abuse and neglect, but all records generated as a result of that. So the statutes themselves are broader than just medical records or other materials that have been inputted into FISFIN.
Okay, all report, where is this 202? Tell me where that all reports.
In 39.202, we see, or all records. All records.
And it says all records are confidential and exempt.
Except with respect to designated individuals.
Okay, and then where is the part that says those records have to be disclosed as part of the case record?
Well, that's where 39.00145 comes in, Your Honor.
And it implies certainly strongly that it doesn't mean every possible document that has been generated in the course of the investigation, because it says at a minimum, it must include these bits of information, and then under 39.0121, the department is specifically authorized to adopt and amend a set of rules that implement, including but not limited to the following: confidentiality and retention of department records, access to records, and record requests. So the legislature has specifically delegated those questions to the department, correct?
I do not agree with that, Your Honor. That is.
Well, they used the term specifically authorized. They said specifically, you included that on the list.
But that's a list of that's inexhaustive. I mean, the use of all and any in those two statutes is broad and expansive.
So where is the line that a court can't cross? I mean, what was the judge's reasoning here? The judge said anything related to the dependency or related to the child. So that's a very broad category. In fact, I would submit there's no real category there.
Well, with this particular child, he was in the dependency system. The rule is the order is limited to this particular petitioner.
Okay, but what happens when another child comes to this judge asking the same thing? So there's no ruling that's actually limited. I mean, otherwise we wouldn't have all these amicus briefs in this case.
Well, it would be as to the facts of the case. At least the Open Records Coalition's amicus brief is talking of policy reasons and legislative reasons as to why these records are important, also beyond the scope of litigation. In this context,
understandable, but aren't the courts bound by confidentiality and accepted from the open records portion of Chapter 119, except as expressed in this exemption?
Yes, but that
and the exemption is for the case. I think the legislature says case record and the department says case file, or vice versa. But the exemption that's the extent of the exemption, is what's in that case record. And you're suggesting that the exemption goes beyond that. And I don't see, I'm wondering what was the court's reasoning for that? Just because it related to the dependency?
Well, in this particular context, yes, it was a child.
Well, what other context would there, in another case, that exemption wouldn't go to documents created in the dependency?
A child, for instance, who never entered dependency because DCF didn't.
Okay, well, let's assume that that in every case involving a dependency, the court has issued a ruling saying every document generated in the course of that dependency has to be given to the child under Chapter 39 at no cost.
Well, in this case, it's limited to the petitioner, but the rule says, or the statutes say that, Your Honor, that any record in a child's case record
in the case record. And if we look at the administrative code rules, the case record is not merely limited to FISPIN. It just isn't. And then if we look in the contract, we've also submitted the contract between ECHR, the lead agency, and YFA. DCF's own rules, specifically CW 230 talks about the case file and FISPIN.
Well, I'm sorry, I'm going to just, if I may, this goes to the question that I asked your friend on the other side. We're engaged in sort of an interpretive exercise here of a collection of rules and statutes that doesn't meet, I think, the conventional understanding of sort of a bright line principle of law, that crossing it results in a situation where it's proper to invoke this type of extraordinary jurisdiction. Help me understand how what you're advocating for the basis for the ruling is of that nature. And, in simple terms, what I'm saying is I'm questioning the propriety of mandamus as the remedy here and the exercise of jurisdiction in mandamus.
when we're dealing with public records and access to those records, and these are not traditional public records, I understand, they're form of public records that are available to select designated group of people, including here the child and the attorney, the requesting attorney. Case law says that mandamus relief is appropriate to compel the enforcement
of a clear legal duty.
Of a clear legal duty, well, with respect to public records.
But the breakdown in the analysis is the clear legal duty with respect to the records that you want to get, texts and emails that are not spelled out as a clear, arguably are not spelled out as a part of what would be a clear legal duty to produce as the record. And that's a threshold issue in my mind.
Well, and it doesn't need to be spelled out. The way the statute reads, the broad language of all and any, this court already in Critical Intervention Services, Inc. versus City of Clearwater, which we also cited to in our answer brief, found with respect to statute that indicated that certain information in security, having to do with security systems, should be withheld from the public at large, stated that the term all means every, any, whatever, and would appear to provide no limitation on the type of form or of information that may fall within the statute's coverage. And so we have a very similar situation here. The statutes don't have to list every single piece of documentation or information that would come under that purview. The broad language itself would.
No, I think the statutes though gave the department the responsibility of making that determination for what constitutes the case record or case file, as the case may be.
Well, and Your Honor, if that's the case, then the department agrees that emails and text messages and other electronic information are public records or something that need to be maintained.
But they're not part of the case file for the juvenile, and all the records for the juvenile and the dependency are exempt from public disclosure, but the case file is available to or a case record is available to the child at no cost. And the department is agreeing, yes, we agree that we should disclose texts and emails, but we need to be paid under Chapter 119 in the normal course. And that's the issue here.
Well, but there's, again, a minimum of records that would constitute that case file.
Yeah, at a minimum, it says the case plan, the full name and street address of all shelters, foster parents, group homes, treatment facilities, or locations where the child has been placed, period.
Your Honor, DCF,
that's the minimum. That's the legislature used the term at a minimum. And beyond that, I would suggest that the statute says the department should figure the rest of this out.
DCF, if that's the case, DCF Operating Procedure 59 is instructive on this. It discusses that the automation of public records must not erode the right of access to those records, and that emails are public records which are to be open to public inspection unless specifically exempted by the legislature.
Right.
And
but
so
every public record under Chapter 119 is available to the public if the public pays for the research time and cost of copying. That's the issue here, not whether the public gets them free of charge under Chapter 39.
Your Honor, I think the legislature was clear that those costs were intended to be borne by the agencies and not by the requesting child. That was the legislature's intent, that it would be broad. And, not only did we, but also in the Open Records Coalition, you see that legislative history and what the concern was, wanting to make all records of a child independency accessible to that child.
But that's not what the legislature said in the statute. And I actually used to work at the legislature and I wrote this legislative analysis, but I never got to write a bill passed in the floor, and vote for it. So, I mean, the legislative analysis can give some insight to what the staff was thinking, but we have to go by the language in the statute. We are in the age of textualism, and we have to go by what the statute says.
I appreciate that, Your Honor. And again, the statute uses the language all and any. So it's not limiting what constitutes a record in the child's case record.
Okay, we have helped you use your time, Ms. Shire.
It's all right. Thank you so much.
Okay, thank you.
We ask, of course, Your Honor, that the order on appeal be affirmed for the reasons we discussed in our papers, and also policy reasons, legislative history found in the Open Records Coalition's amicus brief.
Thank you.
Thank you.
Ms. DiFiore.
So I think the discussion that was just held is pretty much an example of exactly why we think the order needs to be reversed. This is a discretionary issue that was vested in the DCF. And if we're going to say that a DCF rule is contrary to a statute and doesn't properly implement the legislative mandate, then I think DCF has to be involved. It has to be a much more substantive hearing, and it's inappropriate for a writ of mandamus. And in this case, the judge just simply was convinced that the children need everything they ask for at no cost, and went beyond what's in the rules and what's in the statute to, from our perspective, she just completely overrode the DCF interpretation of the legislative mandate and their own rules. And again, it isn't about keeping the information. It is about whether or not it's mandatory to be in the FISBIN. And they're asking to go beyond FISBIN, and the DCF has said FISBIN is the case record. So we'd ask that you reverse. And actually, we don't know that if it should be reversed and say, we're going to vacate this or the last order, and you just don't have a jurisdiction to go further because they filed this as a petition for writ of mandamus, or if there's a procedural method where the judge could convert it into some broader hearing on that issue. But we just ask for it to be vacated. And
Well, I was going to raise that, I mean, we could reach both orders. We could reach the whole thing, because anything that happens before the filing of a notice of appeal is within the scope of review for that notice of appeal. But you're not challenging the first order. Is that correct?
So I think everything that was addressed prior to the text and emails was properly within the scope of the 119 or the 39.00145.
Comes in the second order.
Yeah, so it was the second order that we went beyond the case record in 39.00145, and that's what we'd like to have vacated. And I think the judge's work was done when, in other words, there's nothing further to provide. So whatever happened at the prior hearing in July, that's the end of the case. And then the extra relief would be denied.
Okay. Anything else?
No, I think that's everything, unless y'all have more questions for me.
No.
Thank you so much.
Thank you both, and kudos on a nice job under heavy fire. In order to leave our virtual courtroom, you need to click the button on your Zoom screen. That says,
I do have one comment.
Oh, go ahead. You're still
I
in your
usually
rebuttal.
talk incredibly fast, but I think Miss Hoogland had definitely beat me on the speed of talking today.
She did
It
good.
was amazing.
She did well. She did well.
Thank you.
Okay. In order to leave, you have to press the leave button. Click the leave button, and you'll disappear into the ether.